Number 85, Lubonty versus U.S. Bank National Association. Good afternoon, Counsel.
May it please the Court? Good afternoon. It's Peter Cameron, Lester & Associates, for the appellant Greg Lubonty. I would like to reserve 3 minutes for my rebuttal. Thank you, Your Honor. This appeal concerns the interpretation of Cplr 204A, which is the tolling statute. 204A says when the commencement...
Counsel, how would you, we know the statute, but how would you apply that statute? So what would your rule be? We're looking at the next case. What would your rule be on application of these two statutes, the bankruptcy toll and our CPLR stay?
Well, the way the statute is written, if an action has already been commenced, a foreclosure action or whatever action, and a bankruptcy is filed, the commencement was not stayed by the bankruptcy stay or any other stay.
So no time would be excluded, what, forever for the length of the underlying foreclosure action in this case? What would your rule be? What would you deduct from the period of the stay?
I wouldn't deduct anything. Section 108 of the Bankruptcy Code provides a savings clause in just that event that says 30 days after the...
Sure, the Bankruptcy Code has its own stay, but that and the history of that stay says you look also to the state law. So I think the bankruptcy stay is not particularly relevant here. So let's go to the CPLR and the bankruptcy provision that says, you know, these are stayed, continuation is stayed. You have this case with these stays. Why do you not count under your rule? How do you apply it? Is it for the time where the first two foreclosure actions were pending? So let's say instead of the facts we have here, in the first foreclosure action, it's dismissed within a month, but the bankruptcy stay goes on. Would that count?
I'm not sure I understand. When you say it's dismissed within a month...
But the foreclosure action is dismissed, right? It's gone.
Prior to the bankruptcy filing?
The bankruptcy stay is still in effect, let's say for 3 more years. Does that count for the next time you commence a foreclosure action?
But was the foreclosure dismissed while the bankruptcy stay was in effect?
Yes.
I don't see how that could happen.
So no toll for any of the period of that bankruptcy filing?
No, not at all.
So what you're saying is that there couldn't be proceedings in the foreclosure action to effectuate a dismissal while the bankruptcy stay was pending. Is that what you're saying?
Correct, Your Honor. The bank would have to lift the stay.
Could the bank that's foreclosing go to the bankruptcy court and say, would you just let us resolve, would you effectually stay the stay so that we could resolve this issue?
Banks always make motions to lift stay in bankruptcy court.
Lifting the stay, yeah.
And to proceed with the foreclosure. Okay. That's exactly what
So
you're
that's the point. So you would have the foreclosure action, it stayed. So as long as that bankruptcy stay is in effect, you're kind of in limbo because you can't dismiss, you can't do anything.
Both parties are in limbo, yes.
Then it lifts, and the motion, the first foreclosure is dismissed. So now if you're going to refile under your theory, the second foreclosure action, you've got no period of stay that you can take advantage of.
Correct, Your Honor.
But you have CPLR 205, and also you can ask for additional time to serve under...
Correct. That was our argument. If there are carve-outs in 205, and one of them is lack of personal jurisdiction, which is
What if
relevant.
I had a fraud claim from the same transaction, but I hadn't brought it. And now this happens, both these things happen, but instead of filing a foreclosure action in December 17 or whatever it is, I file a fraud claim. Do I get a toll?
For a fraud claim, I don't see why not.
So it's not a could have brought type of thing. It's not a subject matter test.
Not at all, Your Honor. I think if there's a different cause of action that's brought.
Even related to the same underlying facts. So instead of a contract, I have a fraud. So what would the purpose of not counting the tolls on the other one be then?
Well, if you're bringing a fraud claim, it's based on the same, I guess it would be on the obtaining of the mortgage.
Right.
That's different than a default on a mortgage. It's a completely different cause of action, and it's actually not, I think, based on the same fact.
So you'd have to have some kind of test on how related it was to the original cause of action?
I would think that would obviously have to be done. I haven't seen that happen myself.
Well,
But
is there any basis for that in the statute? Because what I struggle with your claim is that services, it's the second time around in the foreclosure, service is improper on the second time, it's thrown out, and so there's an anticipated third action that isn't brought, and isn't the commencement provision of 204, doesn't it work the same against the first time you bring it as the third time you bring it? It's still the same cause of action. And you seem to be saying, no, that we have to look behind commencement to see what the cause of action is to determine whether or not it would count.
that's in the case if it was a different, this is a mortgage foreclosure action.
Right.
And that would be a fraud action.
So do we have to look behind the cause, behind the just commencement of any action, or do we have to look to say, no, here the bankruptcy stay applies under 204, here it doesn't?
I think you would have to look behind.
So
if there were
state
different-
law then would pick and choose between which ones could go forward to the bankruptcy?
What do you mean?
Between a
I'm sorry.
fraud, say, and a foreclosure action?
Well, if they were both brought at the same time, the same test would apply to both of them, or the same rule would apply. But if instead of the third action being a foreclosure action, it was a fraud action, you'd have to look at it to see if those
Maybe my question is clear. You understand on the third action, assuming it's a foreclosure action, all right? On that third action, you're saying they can't bring it, right?
Yes.
All right, okay. So I'm saying to you, they've already brought it twice. What's the difference? And the foreclosure and the stay would have treated those other ones differently, right?
Yes.
All right, so what's the difference between this one and those previous actions?
This new one being a
Right.
foreclosure action. It's past the statute of limitations. The tolling didn't apply to the first two. So as soon as the second bankruptcy was dismissed, or the stay was lifted in the second bankruptcy in November of 2013, the statute of limitations ran. Maybe there was 30 days after, but the second foreclosure wasn't dismissed until the next year. Once that foreclosure was dismissed, the 6 years had run.
But isn't this a particularly bad toll to apply your rule to? Because, again, as we were discussing earlier, you can't even dismiss your action. I mean, you could go to the bankruptcy judge, but you can't go into a New York court and say, I want to dismiss this action, and then, I would get the toll because I realize there's a problem here. I'm stuck. I'm in limbo, and this time is ticking off the clock, but it's not counting as part of the toll. It's counting as part of my statute of limitations. So for this one, it's kind of a particularly bad one, it seems.
With respect to this case, I don't think it is, though. Prior to the second bankruptcy, the appellant had filed a motion to dismiss based on lack of service. That motion was stayed for approximately 2.5 years. They had plenty of time to look at it and see what they wanted to do with it.
But what could they do then? I mean, again, putting aside going to bankruptcy court, what could they do in that New York action at that point, even if they realize service is bad? What could they do?
If they realized service was bad or that they had an issue, they could have made a motion to lift the stay.
To the
and fix
bankruptcy
it.
court.
Yes, and tried to fix whatever they wanted to fix. What they did afterwards was decide to fight it out on service.
And if
Or
the
they
court, and if the court didn't grant, if the bankruptcy court didn't grant that motion, is there anything else under New York law that they could do?
Under New York law, I don't believe they could have voluntarily discontinued.
But could they have moved under 306B for additional time to serve?
After the stay had been lifted, yes,
Yeah.
of course.
How
they
much
could have.
time was left after the stay was lifted?
Of the 120 days to serve, I think they were at 136. If you take out the bankruptcy time, I think that motion would have been granted almost as a matter of course.
They certainly had enough time to think about it.
Thank you, counsel.
That's my argument. Thank you.
Counsel?
May it please the court, Skylar Kraus for the respondent, U.S. Bank National Association as trustee.
So why isn't he correct that you did have an opportunity under New York law to avoid these harsh consequences by at a minimum seeking or putting in a motion to extend the time to serve?
Well, I
Proper service.
disagree with the proposition. Under 306B...
What part of the proposition?
Well, the entire proposition, actually, Your Honor,
Okay.
because under 306B, first of all, you need to make that application within the time frame of the 120 days
Within
you've
the
been
120,
given.
not outside?
Correct. Secondarily, there had been no determination that service was improper. It was unclear what needed to be fixed, perhaps, and you can come up with a variety of examples as to why that rule wouldn't work. In fact, in this case, the motion was made. The appellant was served with process. 3 weeks later, he files a motion. Within 2 weeks, within days, he files bankruptcy. It is not until the bankruptcy is dismissed that then motion practice continues. Then,
Sure, because you've got the stay in place.
right, and so there's no...
Well, you
there's-
certainly had enough time to think about the motion that there was not proper service to determine whether or not there was proper service, correct?
Certainly, it is, you have time to think about the issue and the motion that's made, but there could be many factual circumstances which would prevent you from determining the risk on going forward or having a motion.
I guess what I struggle with in your cases, I count 5 options that U.S. Bank would have had, and the first one would have been you could have moved for relief from the bankruptcy stay in order to settle the personal jurisdiction issue when the issue arose. Second, you could have moved for an extension of time to serve process per 306B. Third, you could have moved to reopen the bankruptcy proceeding itself. Fourth, you could have moved to commence a new action to the 30-day window. I think it's 11 USC 108 C2. And, of course, you could have served Lubonty correctly in the first place, which would have been easier for everybody, probably.
Other than that last one, are all those options available while the stay is in place?
Are all those options available? I mean,
He's just listed.
an application can certainly be made to the bankruptcy court whether or not it's
Right,
granted.
so it all depends on what the bankruptcy court does.
Correct. And in terms of...
But that's, in a situation like this, that doesn't seem unusual. I mean, to the point where the petitioner had been castigated by one of the courts as using the stay as a sword rather than a shield. It seems to me that it would have been quite easy to make an interest of justice argument here.
Under 306B?
Yeah.
Well, I understand, Your Honor. I think alternatively, a litigant should be allowed to rest on their proof and given the benefit of a statute of limitations and determine at some point, we believe that service was proper, and if it is determined to be improper or ineffectual, then we will have enough time to then serve and correct. And here, a 6-year statute of limitations, because of these bankruptcy filings, was reduced from 6 years to really a year and a half. And to the point of the witness, and the last point you raised, Your Honor.
Oh, so you wanted another 4.5 years? Is that what you're saying?
Pardon me?
You wanted another 4.5 years
Well, I
after the
think you
stay
should-
was lifted?
Our position, Your Honor, is that the respondent in this case should be given, and was given according to the Second Department, the credit for the amount of time that they were prevented from either continuing or commencing.
But it seems to me that your argument is based on what you think is an unfair result in this case. And that's not generally how we make law. And here we're interpreting a statute. And we have to look at the language of the statute. And the language talks about commencement. And the other thing that we have to look at when it's not entirely clear, maybe there, I'm not conceding that there's ambiguity, but let's assume there is some ambiguity. Let's look at the context. Let's look at the whole statutory scheme. And here you have these other pieces. I mean, to me, 205 says that the legislature realized that sometimes when you get dismissed for lack of personal jurisdiction, you know, you're going to be out of luck. But it provided that avenue. It provided 306B. You know, there are just so many ways that this could have been avoided that I'm not sure how we as a court, as opposed to what the legislature might want to do, gets to read this statute in a way that there's no indication that it was intended to apply. It says commencement.
2
right?
points. And to that last point, Your Honor, actually, I believe that it could be read, 362 provides that there is a stay from continuation and from commencement. And so if you look, that's a bankruptcy code, right? You're not allowed to commence or continue in a variety of other actions by creditors against a debtor. So if you look at 204A, if you're reading the text of it and just applying the words as they appear, the statutory prohibition under 204A is 362. And 362 says you cannot commence as well as other actions. And so I think it could be read that the statutory prohibition that triggers 204 here does prevent commencement. Now, it's irrespective, I would argue, on whether or not an action has previously been commenced or is currently pending. The statute that triggered 204A prevented commencement. We could not dismiss without permission of the court, and we could not recommence.
It was already commenced. So that's where I think maybe the ambiguity comes in, and the legislature could have said commencement or continuation. It didn't say that. It said commencement.
If I may
I thought in part your response to many of the questions that Judge Stein was asking, a question I asked before, is that there is not another provision of the CPLR that would have prevented this harsh result, that there is nothing you could have done, other than, of course, as Judge Fay has already pointed out, as your adversary points out, serve properly to begin with. Put that aside for the moment.
Well,
am I misunderstanding you? That
is,
these other provisions were just simply not available to you, even though he's pointed to them?
Correct, Your Honor. And if I may, just on the two...
Was there any equitable argument you could have made?
Or
equitable tolling, anything?
Equitable tolling below?
If your position is, we thought we properly served until the court tells us otherwise, we see no need to make a motion, and in any event, by the time the stay is lifted, we can't proceed under any of these provisions.
If the rule is that you do not get any tolling credit because you, as a claimant, actively sought to pursue your claim and you're punished by the fact that a bankruptcy followed, then I'm not sure what the equitable tolling would be because then...
The argument is just unfair because you could not, right? It's the argument I thought you were trying to make, which is there is no other provision that addresses this particular situation. Put aside your arguments that you think he was gaming the system. That there's nothing else that addresses this. When you've got this stay, you can't act in the state action.
Correct.
Even if you went to federal court, let's say they turned down your motion, they rejected the motion, denied it, you're stuck, no other provision applies.
I misunderstood your question previously. I apologize.
I could understand
I agree
how you
with
would
that proposition that yes,
okay.
there is no, it would be inequitable, and it is inequitable. And if I may just address
but you did not seek to make any of those arguments in state court, correct?
Those are not in the record.
And you did not raise that here?
That it would be inequitable? I believe we have...
Well, no, that there might be some type of equitable relief.
Let me ask you this. While your foreclosure action is pending,
Is there anything in the CPLR that prevents you from filing an identical action?
Yes.
What?
And that's actually, it was pointed out in the reply brief that 3211 suggests that you could have another action. In a foreclosure context, you cannot. RPAPL 1301 prevents you from filing a second action. If I may just address the 205 argument, an issue. Yes, under a service, if service is the issue, we've discussed why there's a carve-out for that, and perhaps 306B could be a remedy. However, voluntary discontinuance is also one of the carve-outs. And I don't think it would be difficult for the court to come up with various circumstances where it would not only be inequitable, but it would also be counter to the administration of justice and overwhelm the courts. So you could,
I guess my point there was that the legislature did create these carve-outs, but we have to presume they knew what they were doing, so that it wasn't intended to give a break in this particular situation. But as Judge Fahey has indicated, there may have been other remedies.
and for a voluntary discontinuance, if there, let's say, predicate notices, there's some issue as to whether or not they were served, or an issue of fact, you could file an action. You could believe that you properly sent those to the right address. If bankruptcy could be filed, you could realize after the bankruptcy that goes on for years and exhausts your statute of limitations that predicate notice, there's an issue there and that you should not be proceeding. However, in this circumstance, if this is the rule, then a plaintiff will have to proceed, because you'll have to proceed and then lose on the merits as to the predicate notices, and then you could recommence under 205A. But if you voluntarily discontinued, you would be carved out and it would be inequitable.
Thank you, counsel.
Thank you very much.
Counsel?
Just briefly, with regards to the 306B, and there was a motion to dismiss based on lack of jurisdiction, which was pending when the bankruptcy was filed. They knew how they had allegedly served the defendant and at which property. All during the bankruptcy, which respondent had participated in, it was clear what appellant's address was, his correct address. They had plenty of time to plan on what they wanted to do. And there is no guarantee that the bankruptcy court would have granted a motion.
So what could they have done? Because there's a stay. Is it that they could only go to the bankruptcy court and say, lift the stay, period, or let us serve? Could they ask the bankruptcy court if they could serve properly?
That would essentially be the same motion. If they wanted to lift the
There's
stay.
one thing to lift the stay completely and let the proceeding proceed versus just to allow service.
I think if they made a motion to lift the stay just to allow service, I don't see any way that we could have opposed that. I think the bankruptcy court would have granted that. If it was to lift the stay as to the whole foreclosure action, it could have been opposed, but there's no dispute that the appellant had not made any payments at all. So there are numerous grounds to lift the stay. I think a motion would have been granted. There's no guarantee on that, though.
Thank you, counsel.
Thank you.